in one of the rules that was proposed that would enable us to identify the issue that when a lawyer is providing any even non-legal services in which the lawyer has undertaking a fiduciary duty to the client to whom the lawyer is providing those non-legal services, the lawyer still owes all the duties that the lawyer would owe to a legal client. And that's what we were trying to do, trying to make that crystal clear upfront for people to understand and clarify what was going on in this rule. One way of explaining Rule 5.7 is it's a rule to avoid confusion of non-lawyer clients of the lawyer, to ensure that the non-legal clients of a lawyer understand that just because they are obtaining services from a lawyer does not necessarily mean that they get all the protections of the attorney-client relationship. And the rules regarding ownership and so forth are much more relaxed under Rule 5.7 because you're not providing legal services. And therefore you can jointly own an entity that provides these non-legal services without running afoul of Rule 5.4. So that's where the rules are. And we didn't, I'm not sure whether we recirculate, I think we recirculated the rule in the final report, but the rule was never sent out again for public comment for any intake. That one thought was to request that the Board of Trustees issue our proposed rule for public comment when we submitted the report in March of 2020, but that was never done. And instead, it became a recommendation that the rule should be considered further outside of a sandbox by this working group, which was then not named, but eventually was named and came into existence. So that's really what the Rule 5.7 is all about. The memo that Marta and I drafted, we were just simply trying to get you a background of information, the history of Rule 5.7 in California, to know that the territory is already covered in California case law. There's no problem with lawyers engaging in this right now. This rule isn't necessary to enable lawyers to form entities with non-lawyers to provide non-legal services. The rule provides cautions, but all of that is in the case law. The duties that are imposed under ABA Rule 5.7, those duties are imposed under California case law right now. The thinking was simply that if we have a rule, this would become more apparent to other lawyers, and they might not be hesitant. They might think, hey, this is a good idea. I know a computer programmer who's interested in doing these, developing some law-related software programs. And maybe this will be one mechanism that we can use in order to do that. And that's pretty much what the memo tried to cover.
I appreciate that. And I think the memo did cover that. My takeaway from the memo was that the proposed Rule 5.7 that Atos bequeathed us is supposed to mirror what was at the time, and perhaps still is, the state of the law, so that it's actually accomplishing no change in the law at all, except for this greater transparency. Is that still your understanding, Kevin?
That is still my understanding. And I think there's a thing, it's numbered page 11 in the materials of the, it's page 11 of the memo from Mark Tuft and me dated February 18th, 2020. And I apologize for that. My dog thinks my job is to devote my entire attention to him. And he's getting a little bit upset that this meeting's going on a little bit longer. But so it goes. Okay, so it's on page 11 is the, this is the,
I think you're talking about page 11 of a different document from the one Mimi has put on the screen.
yeah,
Because you said it
it's-
was a memo from several years ago that you and Mark Tufts wrote.
yeah, I think it's, but it was part of the materials.
Yeah, it's
that,
this is the
I mean-
excerpt from the report, I believe, that Kevin's
Yes.
referring to.
I see, got it.
It's page 315 of the materials of the
Okay.
PDF, the compilation.
Got it.
Thank you.
Yeah, and section D and comment 1 are highlighted in yellow. That's
Yeah.
how you spot
Correct.
it.
Let's see if I
Got
can
it.
Find my compilation.
So given that this is a rule that basically just codifies existing law, this is probably a good opportunity for me to jump in and remind folks, our plan is to release to recommend to the State Bar Board that they release for public comment next year, first of all, a set of proposals relating specifically to a sandbox. And that a couple of months after that, separately, that they release for public comment a series of rules not involving the sandbox, but otherwise within our charge. And so this rule is not about the sandbox, but is otherwise within our charge. So I think we will want to either say to them, please put out for public comment the rule that Adels previously wrote into their final report and have bequeathed us. We propose exactly the same language, or if there's a reason we don't want to do it, explain why we're not asking them to do that, or if there are some very minor tweaks to put those in. So that seems like an issue that we can reasonably put off until closer to the date for our recommendation, not sandbox related, but rules specific. Does that make sense to you, Kevin?
Yes, it does. I think I'm glad you said some minor tweaks because I think there are some tweaks that need to be made to the rule.
I appreciate that you are the man who would know what those would be, and that we should certainly plan to do that sort of thing, but I would recommend that we not do that in the immediate term. But thank you very much for bringing this much of it to our attention. And with that, unless there are people who want to comment specifically on proposed Rule 5.7, I recommend we move to proposed Rule 5.4 or to the topic of revisions to Rule 5.4.
Okay. Okay, no comments on 5.7. I'll move to 5.4. And I think my ears have been burning from as I felt when I was at my faculty meeting. Let me explain, and let me go back to the ADLS task force and explain why the recommendations are made that perhaps we shouldn't try to go outside of the sandbox and instead should just focus on the sandbox in any changes that are going to be made. And that's pretty much summarizes what the memo states. And going back to the ADLS task force, of which, as I've said before, I was a member. A number of the other folks here on this Zoom call right now were members. And they may disagree with me. I'm giving you my sense of what was going on. And we were it was kind of overwhelming. It was overwhelming for staff and the members. We had a lot of technologists who were very up and very smart about the use of technology. And it was a pretty steep learning curve for some of us lawyers, particularly some of us older lawyers, to catch up where everybody was going. We had, as I mentioned earlier, 3 different subcommittees. And each of these subcommittees at each of our plenary meetings would meet separately at the beginning of the meeting, and then we would gathered together, typically in the afternoon, and exchange the information and what we had done. And it went along, and to me, the process at the beginning was a little bit disjointed, but we had to get out an interim report and send some recommendations out for public comment. By June, we had to pretty much focus on that. We had to finish the drafting of that interim report, get it to the Board of Trustees so that there would be enough time, at least a 60-day public comment period. Because at the time we were discussing all of these various topics, we only had until the end of 2019. And we didn't actually get together and start discussing this till the beginning of 2019. So by June 2019, we had to get everything together. We had a lot of discussions on disparate topics. From my perception, we were a little bit disjointed, and each group seemed to come up with its own recommendations. The staff did an absolutely marvelous job of pulling them all together. And we sent out a series, 3 series of recommendations. Curiously, I looked at the interim report and I was really surprised. And then I remembered, yeah, it makes perfect sense. The word sandbox is only used a couple of times in the entire interim report of several hundred pages. That was not something that we were focusing on. The public comment came back. As I recall, we got thousands of public comments, mostly in opposition to the proposals that were made, mostly from lawyers or lawyer ethics committees that were raising concerns about many of our, for the most part, generally recommended proposals. And there was some great fear about them. And, we got it all back. We had meetings in the fall of 2019. And then this is what my perception, and people can disagree with me. I thought that a consensus coalesced around 2 primary recommendations. One was a sandbox, and the second was a paraprofessional, a core of paraprofessionals who would be able to deliver legal services in certain limited legal services, perhaps patterned on the limited legal legal technicians in the state of Washington. So the focus of the final report of ADLS, which I think most of you have seen, is really the major recommendation was the sandbox. The other major recommendation was a paraprofessional group, and there was already, I believe at the time that our report came out, the paraprofessional working group had already been appointed and had met. So those were the 2 main things that were going out. And it seemed to be the best way to approach any changes that were going to be made to the rules would be made within the sandbox or would be made in reference to the paraprofessional core that was being developed or would be developed by the working group. And that was pretty much, since we've been here in this working group since we convened earlier this year, our focus has been on a sandbox. And yes, we have these other rules that are part of the charter. And I apologize for not being able to be here for the discussion of the advertising rules or the lawyer referral service rules. We're now discussing 5.7. All of those rules, fine. We can look at them, but I think that 5.4 is going to the heart of this non-lawyer investment, which seems to be what the sandbox is designed to address, to provide us with data, to let us know whether this approach, where perhaps we can, and again, I don't like using the word, but relax the prohibitions in Rule 5.4, but if it's done within a sandbox, which has always been described to me as a controlled environment. I think some folks might say, well, gee, if they're providing legal services, if there's no other limitations on them, how is it a controlled environment? But to get the go-ahead to do it, you have to pass muster instead of just throwing out Rule 5.4, as Arizona did in Rule 5.7, and then say, okay, apply, and come up with a good idea, and then we're going to let you go out. And now we're going to regulate you. And then you might say, well, gee, how much of a difference there is. But by doing that, are we really prepared to create a separate regulatory framework that addresses the issues of ABSs, the alternative business structures outside the context or environment of a sandbox? Are we prepared to do that in addition to creating a sandbox that is going to be doing the regulation? Now, it might be that you could merge the two functions, I don't know. But I just thought that we were better off and to try to simply do what is described in the memo as the necessary changes to Rule 5.4 that will accommodate both the paraprofessionals having co-ownership or joint ownership of a firm with lawyers, and also any other non-lawyers who are in a joint ownership situation with lawyers within the confines of a sandbox. And that was the proposed rule, and it's a very rough draft.
So Kevin, maybe I can jump in here, especially in light of the presentation we got from Arizona. I realize there isn't a lot of time left, and I don't know whether there's a lot of comments people want to make, but your memo, the one that you and Patricia have presented the group with, pretty much says, let's do sandbox, not separate relaxing of Rule 5.4, as you just explained. We heard in Arizona the opposite approach. Let's not do a sandbox, let's just have regulated entry into a 5.4 free world. And I would be interested whether there are people on our committee who find the Arizona approach more attractive than a sandbox, or whether, even having heard about Arizona, we are still, how many of us are still of the view that the sandbox is the, I don't know, preferred or preferable approach rather than direct intervention on Rule 5.4? That seems like kind of the big question that I would love to hear some feedback on before we focus on the narrower issues about accommodating paraprofessionals, since that's, since that's a smaller issue. And I see that we have two hands raised, perhaps to address that issue or perhaps otherwise, but I'm going to have to call on Wendy first and then Andrew.
Thank you. I found that Mr. Moore's comments were really helpful for me, and clarified that there seems to be two separate issues, as well as the memo did. One is, should we have an expansion outside of this regulatory structure? And that seems to be one question. And I would ask that we split those questions up. One is, should we have more of an unbounded expansion of 5.4 or 5.7 without a regulatory structure, and 2 is about the sandbox. And so I found that articulation was very helpful for me personally, and I thank you for that. And I would ask that we look at it in that way. And I think the legislature has shared with me that they're concerned about following, that California is unique, and unique in their support of consumers and consumer protection, and wonders about how consistent other states' approaches are with California's approach. And so I would support not having an unbounded 5.4 or 5.7 outside of a regulatory structure. And I think we need to think long and hard about, whether we within a sandbox structure, how much we change or waive 5.4 and 5.7. And thank you so much for the excellent materials. They were helpful for me personally.
Thank you. Andrew.
So as someone who was also there in the room when it happened, as it said, I think part of the challenge around the conversation around 5.4 was also just us working around different groups who also wanted to go the route closer to what you saw in Arizona, and therefore kind of split it up and then provided the recommendations as it were, mainly also to hit the ambitious timeline for the ATIL's kind of report to come out at the end. So why am I saying that? I think, I do think there's merit to us considering the removal of 5.4 or the recommendation of that. I also think it's important to note that when ATIL's was convening, what had been occurring in Arizona and the final decision there hadn't occurred as of yet. And so one thing that I think that was quite helpful was hearing from Justice Timmer today and seeing the data there and seeing that it actually hasn't led to any harm and that there hasn't been any complaints. I think that we should always go where the data is. And part of the reason why we have a sandbox is to get data where we're unsure of things. But if we're sure and we can start to see in 5.4 and the effect of that relaxation in Arizona, and that what it's mainly meant is that lawyers are now able to team up with marketing folks or folks who can help them on the business side or social workers, et cetera. I think it's a great thing. So I would definitely recommend consideration. I also think, as you see in Arizona, they also are now considering a sand bucket or a smaller pared down sand box approach as well. So I don't think that our efforts so far in the discussion so far are for naught. I think that there are two separate things, and I definitely think we should consider following suit and kind of following the lead of Arizona.
Thank you, John.
I was just going to first note, because our friend Crispin is probably tucked away somewhere by now and hopefully asleep, that he wrote some really excellent comments on this subject that are in the notes, and I think brought forward some things that are just important to remember about what's really going on around this market. Anyway, we can say as a group of lawyers that we just are sure we want to be able to protect consumers, but consumers are finding other solutions because lawyers aren't delivering those solutions. And that type of market force, has gone on for 20 years. As Crispin notes, it's 20 years too late to ask whether or not, non-lawyer ownership should happen, because things are simply moving. And to some extent, this is about it seems to me this needs to be about trying to find the best way forward to get good regulation over what's happening, more so than having the debate about what's happening, because it's happening. And I guess the related point there is we see in Utah some norms developing out of the sandbox, like you should be able to probably have shared ownership with a paraprofessional or paralegal and not need to run that through the sandbox time and time again. So this really goes to Justice Timmer's point that the two models sort of tend to merge towards the center, where we'll find ways to begin to articulate a normative rule probably around ABSs long before around non-lawyer provisions of services or software. And likewise, as Andrew just alluded, the Arizona folks are seeing that they need to maybe make some provision for testing and modeling. So my honest assessment of this is I just think this group has a huge to-do list. And to simply get through even coming out with a meaningful sandbox recommendation is going to be a major challenge, is becoming a major challenge. And the idea of also writing into that sort of an Arizona model that structures something around eliminating 5.4 completely and also leading that role, that's a nice thing to think about, but I don't think our dynamic is going to let that happen. So I guess for that reason, I just suggest we kind of stay to the plan of trying to move forward with a sandbox.
Thank you. Toby, and then Kevin.
I thought John was going a different direction when he started his discussion, but I agree with where he ended up and with Kevin that we should focus on the sandbox. I was another one of those people who was in the room. And I think what happened with the discussion about should we also consider 5.4 independent of the sandbox was came up at the very end. There was certainly no serious consideration about what it means. There was no discussion of saying, well, if you eliminate 5.4, you got to have these other restrictions on ABSs and other amendments to the other rules. We never got that far. It was just a bunch of things at the very end, including the advertising and including 5.4 and 5.7 and all that were sort of tossed in at the end as part of the let's get everything out there because our time is up and let the next group let what we were calling then ADLS 2 worry about it. So I think I would definitely go with staying with the sandbox. In terms of 5.7, I have less concern about going forward with that one. I don't think that is as, because it's not really changing the law, but just clarifying and putting it in one place where people can find it easier. I'm not sure a sandbox is quite as essential for that piece of it and would be comfortable going forward with that.
Thank you. Kevin.
Yeah, just very quickly, well, I guess everyone knows, if you've read the memo, that I agree with Toby and what John said to focus on the sandbox. But I just wanted to make one point that Andrew was talking about, we know from Arizona. I don't think we know anything from Arizona yet because they've only been in operation for a few months. So let's, wait until we get some data. But regardless, what I think we should be focusing on is, with all the difficulties, all the discussions we've had so far and the length of our discussions over just resolutions, that it's a very complex, complicated issue to move the sandbox forward. And I think we need to put all of our energies into it.
Thank you. John, did you have a point
Very
before we
quickly,
wrap up?
Since I'm now being described with this position, I want to make sure one thing is clear about it. Another thing Crispin said, which I think is critical, is that we go the direction of the sandbox and abandon this idea of just dealing with ABSs on a separate track. We really need to be committed to a broad and open sandbox. And if we're going to end up with a sandbox that's constrained and only available for certain things, and we've also not given any room for ABSs, I think we'll just have constrained it to the point where we need not have even started down this path.
All right, Andrew, you have the last comment before I wrap things up.
Well, I would agree with John on, and that was really what my worry is, and just the kind of the nature of the conversations and the directions I was offering and seeing that we might be able to make progress with something else that furthers access to justice. So that's a concern. And I guess what I would say in relation to whether we've had the data from Arizona, I totally agree we need more data, but I would say that the sky hasn't fallen and there isn't anarchy in the streets with, people breaking glass and the end of times in Arizona, as has been kind of people have been worried about with rule changes to date. So I agree that we need more time, but I think that what we are seeing is quite promising, and we heard that directly from Justice Timmer as well.
Okay, thank you, everybody. I think we had a productive, not always easy, but very useful session today, all because of the efforts that you all put into preparing for it and to sharing your views during our day. In terms of where we go forward, I think the consensus I'm hearing is sandbox ahoy. let's return to our focus on that issue. If you were one of the people on these two-person teams on the rules, and you want to keep working on the rules assignment you've already started, why don't you get in touch with me and we can have a brief conversation about those efforts. I definitely want those efforts to proceed, and at some point we will broaden out those efforts from the two people who've started on each rule to involve other people. But I also want to make sure, and I think we accomplished a lot by the limited take we did today on those 4 rules, on the rules assignments. But I don't want the work that you're doing on the rules assignments to sidetrack us from the progress we need to make on the sandbox. So that's why I'm not going to push anybody who's currently been working on these 4 rule assignments to do anything by the next meeting or even by November. I'm going to let those go on the slow road. We can talk about that offline, but the concerted effort of the whole group should really be focused on the many important issues that the sandbox discussion still needs us to pay attention to. I know there are SAGE and SCOPE meetings coming up soon, and that we will gather again as a whole group in October. So unless there's any question or concern that needs the whole group's attention, I will adjourn this meeting. Thanks, everybody.
Thank you.
Bye-bye.